Just let me know when you would like me to start.
All right, let's go.
Okay. So, Your Honor, we're here this morning in the case of State of Georgia versus Demetrius McDowell Jr. It's case number 24 SC 002147. Mr. McDowell, can you please raise your right hand for me? Do you solemnly swear or affirm that the testimony you shall give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, and make sure you're speaking into the microphone so the court reporter can take down everything you're saying, okay?
Sure. Yes, ma'am.
State your true, correct, and legal name.
Demetrius Antoine McDowell Jr.
Hold on, Miss. Yeah, you don't have to lean real close. You just have to speak up some.
Demetrius Antoine McDowell Jr.
Are you currently under the influence of any alcohol, drugs, or taking any medicine that affects your ability to understand these proceedings?
No, ma'am.
How old are you?
30.
How far did you get in school?
11th grade.
Did you complete your GED by chance?
No, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses? Counts 1, 2, 3, and 5 charge you with violation of the Street Gang Terrorism and Prevention Act. They're each punishable by 5 to 20 years in prison. Count 8 charges you with murder. That's punishable by life in prison. Counts 9, 10, 11, 12, and 14, they charge you with felony murder. Those are also punishable by life in prison. Count 17 charges you with attempted armed robbery. That is punishable by 1 to 30 years in prison. Count 18 charges you with attempted purchase of marijuana. That is punishable by 1 to 5 years in prison. Counts 19 and 20 charge you with aggravated assault with a deadly weapon, punishable each by 1 to 20 years in prison. Count 21 charges you with home invasion in the first degree. That is punishable by life or 10 to 20 years in prison. Count 22 charges you with possession of a firearm during the commission of a felony. That's punishable by 5 years in prison. And finally, count 24 charges you with possession of a firearm by a first offender probationer. That's punishable by 1 to 10 years in prison, for a total maximum exposure in prison of 2 life sentences plus 70 years. Do you understand that?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Melnick, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to talk to Mr. Melnick about the case?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Melnick, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
I'm not. Yes.
Mr. McDowell, has your attorney advised you of the minimum and maximum sentences for each charge you were pleading to, just as I advised you a minute ago? Everything I
ma'am.
went over. Did you also go over that with Mr. Melnick?
Yes, ma'am.
And did you understand everything that he told you?
Yes, ma'am.
Do you understand that neither the court nor the DA's office has anything to do with parole or the Department of Corrections or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you to the contrary?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be the following sentence? Count 1, participation in criminal street gang activity, 12 years to serve in confinement. Count 17, attempted armed robbery, 30 years to serve, 12 years in confinement with the balance on probation. That's going to run concurrently with count 1. We are tendering a null pros to the court for all the other charges, meaning they're being dismissed. The terms of probation will be as follows, Mr. McDowell. You are to testify truthfully at any subsequent trial in accordance with your statement to Investigator Malone. The statutory gang conditions, which are no more criminal street gang activity and no more contact with any member or associate of any criminal street gang. Also, no contact with the victims, family members, co-defendants, and the incident location. No possession of guns or replicas, a Fourth Amendment waiver, no drugs or alcohol, and also no possession of any gang paraphernalia. We are agreeing to run this concurrent with your other 2 cases, 23 SC 189047 and 23 SC 187394. Yes. The numbers?
And we go through all the charges. We do it all together so that they don't have, so they won't have to go.
Each individual
Sure,
case,
sure.
yeah.
So I don't.
I'll jump in.
She can just go through hers and then Mr. Brown can go through his.
No, it's gonna take longer. Ms. Hall?
Hmm?
Can you?
I'll jump in. Ms. Murdell, in indictment number 23 SC 189047, do you understand that you've been charged with 2 counts of aggravated assault, family violence?
Yes, ma'am.
Do you understand that the minimum and maximum for aggravated assault, family violence, the minimum is 3 years to serve and the maximum is 20 years to serve?
Yes, ma'am.
And do you understand that the maximum on these 2 counts would be 40 years? And the maximum exposure for you is 40 years to serve.
Yes, ma'am.
That's all for that case, Ms. Woods.
Ms. Hall, could you go ahead and do the next case for me while I get Mr. Brown?
Yes.
Thank you.
And then, sorry, I didn't have that one pulled up.
It's,
Is
You-
is
the-
it just the aggravated assault, possession of a firearm?
That's
and
correct.
Possession of a firearm by felon?
no, that count 3 doesn't apply to Mr.
Okay.
McDowell.
So just
it's
the first
counts
one
1
at a
and
time,
2.
So I can do it, Ms. Hall. So Mr. McDowell, in case 23 SC 187394, on count 1, aggravated assault with a deadly weapon, the exposure is 1 to 20 years in prison. On count 2, possession of a firearm or knife during the commission of a felony, that is a 5-year consecutive for a total maximum exposure of 25 years. Do you understand that, sir?
Yes, ma'am.
You have to answer all that, yeah. So the total exposure for all 2 life sentences plus 135 years.
Do you understand that, sir?
Yes, ma'am.
And Ms. Hall, do you want to go ahead and put your recommendation on the record?
Yes. Ms. McDowell, do you understand that from the state's recommendation, or this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for count 1, aggravated assault, family violence. The state's recommendation is 5 years to serve to run concurrent to the other 2 cases. And for count 2, aggravated assault, family violence, the state's recommendation is 15 years to serve 10 years, balanced on probation. Special condition that you have no contact with the victim in this case, Miss Ayana, Ayana, last name Williams. No contact with her, but the judge does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
And just so that we are clear for the record, those sentences will run concurrently with the sentences in the 2 other cases
Yes,
And
and
you-
concurrent to each other.
and concurrent to each other. And this is a plea under Alford versus North Carolina.
Understood.
You want to go ahead and put your recommendation on the record?
Sure. So on, and forgive me because I don't know the SC number, but with the 2 cases that Mr. Senior and Junior have, position 1 and
I think it's 2. So this is it.
Gotcha.
Who was mine?
Indictment 23 SC 189-047.
That's mine.
187394.
Yeah.
Number 4. Okay. Right here.
23 SC 187394. And with respect to that, the state offer would have been 12 or 10 to 10 to serve. I think it was 10 to serve
10 to serve concurrent with the other two.
with the other two.
Yes.
And what's happening with the gun charge?
The gun is 5 consecutive suspended.
Thank you.
Okay. So, Mr. McDowell, do you understand, however, that the court does not have to accept that recommendation, that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated pleas, you would have the right to withdraw the pleas?
Yes, ma'am.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, it may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
What was that?
I said yes, ma'am.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
In addition, you waive the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to a court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges following a trial. By pleading guilty today on the 3 indictments, sir, you're waiving or giving up all of the rights that I just enumerated to you. Do you understand that?
Yes, ma'am.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea to these 3 charges,
No, ma'am.
to these 3 indictments? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
So just for the record, Judge, on the 24 indictment, the multi-count indictment involving the murder case, I think it's 24 SC 002147 or 2. That is an offered plea, as well as the case involving Ms. Hall, 23 SC 189047.
Larissa, we should probably take those individually.
Sure, yeah. Okay, so Mr. McDowell, as to 24 SC 002147, that's my case involving the gang charges. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position as if you were convicted by a jury at a trial? Do you understand that?
Yes, ma'am.
Okay. So in that indictment number ending in 2147, sir, how do you plead?
Guilty.
Guilty pursuant to Alford?
Yes.
Yes, ma'am.
Okay. So in the second case number, 23 SC 189047, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position as if you were convicted by a jury at a trial? Do you understand that?
Yes, ma'am.
Okay. So in that indictment number ending in 2147, are you pleading guilty because you have decided that it is in your best interest to do so? Are you aware that even if you do not admit guilt, this guilty plea places you in the same position convicted by a jury at a trial.
Yes, ma'am.
So in that case number, sir, how do you plead?
Guilty.
Pursuant to Alford? Is that a yes?
Yes, ma'am.
Okay. Now, in the remaining case, 23 SC 187394, how do you plead? Guilty or not guilty?
Guilty.
Are these guilty pleas freely and voluntarily given with the full knowledge of all the charges against you?
Yes, ma'am.
And do you understand that you may have only a limited right to appeal these guilty plea convictions?
Yes, ma'am.
Do you understand that unless counsel is substituted or permitted to withdraw, Mr. Melnick will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Do you understand you have 30 days from the day of your sentence to file a direct appeal?
Yes, ma'am.
And do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition, which is essentially a legal term addressing your ability to address any constitutional defects or challenges to your guilty pleas?
Yes, ma'am.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty pleas?
Yes, ma'am.
And do you understand that any of these filings we have just talked about must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
Paul, before I get into my factual basis, is there anything you wanted to add that I may have missed pertaining to your case?
No.
Your Honor, the factual basis for 24 SC 002147 is as follows. On April 12th, 2023, at approximately 11 at night, armed robbers, this defendant, Demetrius McDowell, the co-defendant who has since pled guilty to 30, served 15, Keontae Jackson, and the third co-defendant, DeMonte McNabb, fatally shot their co-assailant, Calvin McDowell, who is the decedent in this case, in the driveway of 1591 Woodland Avenue in Southeast Atlanta. Terrence Malone was assigned a lead detective in this case, Judge, and he interviewed the victim of the attempted armed robbery. His name is Jarquavius, Jarquevious, last name Everson, Everson. He spoke with him. It was actually Mr. Everson's home where the incident happened. And Mr. Everson explained that just prior to the incident, he and a friend by the name of Roderick Butler, first name is Roddrick, they were at Everson's residence playing video games when they heard a knock on the back door. When they opened the door, he observed the decedent Calvin and 2 other men. The 2 other men were unknown to him, although he did know Calvin. Mr. Everson said that he and Calvin had previously negotiated the sale of 3.5 grams of marijuana. And when Calvin arrived to make the purchase, he began to prepare the marijuana. Everson stated that as he was preparing the marijuana, Calvin brandished a weapon and attempted to rob him. He brandished a gun. Everson said that he ultimately tried to disarm Calvin, and during that struggle for control of the gun, one of the other co-defendants, either Mr. Jackson or Mr. McDowell, they essentially opened fire. Mr. Everson explained that he was successful in getting the firearm from Calvin, who subsequently crawled out of the back door as the other 2, this defendant and Mr. Jackson, continued to fire shots towards the home as the decedent was struggling to crawl outside. Mr. Everson explained that he suffered a gunshot wound during the initial volley of gunfire, and after the gunshot stopped, he secured his residence and then went to the hospital for treatment for his gunshot wound. Mr. Everson then explained that although he he did get Calvin's weapon, he was never able to let off any shots. So the shot that killed Calvin would have come from one of the co-defendants, namely either Mr. McDowell or Mr. Keontae Jackson. Detective Malone found 2 abandoned cell phones, and he examined the data within those cell phones. He found that one of those cell phones belonged to the decedent and the other belonged to this defendant, Demetrius, who also went by the name Lil Meat, common spelling for both. Detective Malone reviewed the call logs within this defendant's phone and found that the person who he last communicated with before dropping his phone during the escape from the home was someone by the name of a Miss Edwards. She told Detective Malone that this defendant, Demetrius, was the person who she communicated with on that cell phone, thereby evidencing that he was in fact inside the home during the course of this attempted armed robbery. She identified him via a single photograph. Detective Malone also found a second number in this defendant's phone that belonged to a person by the name of Miss Williams. She explained that Demetrius was the father of her child, and since the fatal shooting, Demetrius admitted to her what had taken place, and he said he had residence with the decedent and the co-defendant Keontae Jackson, and he admitted to entering the home during the course of the armed robbery. He then said that they left Calvin's body at the home because they couldn't really find him after he had been shot. Detective Malone also learned that a person by the name of a Miss Seaborn was likely the last person to speak with Calvin before the shooting. And during Detective Malone's interview with Miss Seaborn, she admitted that Calvin had come to her and expressed an interest in going to the incident location to commit an armed robbery. After this defendant was apprehended, Detective Malone saw that he had a GPS ankle monitor on, and that placed him again at the crime scene. He also gave a statement and placing himself there and also placing co-defendant McNabb there, as well as co-defendant Jackson. The crime scene tech, Your Honor, found multiple shell casings at the crime scene, 12 7.62 39 spent shell casings and 11 9mm spent shell casings. This defendant, Mr. McDowell, is associated with the national criminal street gang, the Bloods, by way of a subset called Sex Money Murder. Mr. McDowell has a B tattooed on his face and has been seen on social media using language characteristic of the Blood Association, as well as posing with numerous guns and large stacks of money. PDE is a hybrid criminal street gang based in DeKalb County, and the name stands for Paper Drugs Extortion or Paradise East. The decedent was a member of the Blood subset Paradise East Judge and also a subset of that criminal street gang, One Gang. And the co-defendant Keontae Jackson is also a member of PDE. And PDE is known to commit these violent kinds of crimes like murders, aggravated assaults, and also armed robberies. And all events occurred in Fulton County. I would like the record to reflect, Your Honor, that the murder charge in this case is being dismissed, taking into consideration the fact that the person who ultimately died was a relative of this defendant. I believe he was actually his brother. Also, they were in the course of committing a violent armed robbery on this drug dealer, which is another reason why we believe that the negotiation here is appropriate. Because had the decedent survived, he would have very well been a co-defendant on an armed robbery indictment. I also would like to place on the record that Miss Earlene McDowell. Miss McDowell, can you stand up, please? Oh, she's on that side. Okay. So she is the mom of the decedent in this case, Calvin McDowell. And she just wanted the court to know, I spoke with her this morning. She just wanted the court to know that this incident has tragically torn apart and affected her family. She told me that she's lost about 50 pounds since everything happened, just dealing with the fact that one son is deceased, and I believe this is also her son, and he's standing right here before this court. I explained to Miss Earlene McDowell that, you know, it's a tough situation to be in, but something has to be done. I couldn't just very well let him walk out the door with straight probation, Your Honor. So one more thing for Mr. McDowell. Mr. McDowell, you remember giving a statement to Detective Malone, sir, during the course of this investigation on the day that you were arrested?
Yes, ma'am.
And are you affirming that statement to be true today on the record?
Yes, ma'am.
Is that a yes?
Yes, ma'am.
Okay. And Judge, I believe that is all I have.
Judge, there's a lot that I could get into in this case. This is
Wait.
all a negotiated disposition. I'm sorry. This is a negotiated disposition. I will say Earlene McDowell wants less jail time or no jail time for Demetrius McDowell in this case. And one of our primary motivations for taking this plea is the fact that we're not just resolving this case, which had a lot of factual issues, I think, from the state's perspective, but also the other two cases as a global resolution. So I am asking that you accept the negotiated dispositions that we've reached in this case and for the other two indictments that are present before the court today.
Ms. Hall?
Yes, Your Honor. And had we proceeded to trial on 23 SC 189047, the state would have proven beyond a reasonable doubt that on March the 26th, 2023, this incident location that was used was 195 Fairmont Road. That is the victim's address. However, the more accurate location would be the model station on Martin Luther King Drive, which is in Fulton County. The defendant and the victim in our case, Ayanna Williams, they were in a car together. A dispute happened. In the middle of that dispute, the defendant is driving the car at that time. He reaches over and he starts to assault Miss Williams. At some point, he leans over while he's driving and he bites her. And then didn't stop there. He ended up pushing her out of the vehicle while it was moving. She ended up walking to her grandmother's house, and at that point, she called 911. When she made it to her grandmother's house, officers arrived. They were able to see visible injuries to her face. She had bruises on her chest. You could tell that she had been on the ground. Obviously, they didn't see her get pushed out the vehicle, but they could see that she had somehow had contact with the ground. She did have a large bite mark on the side of her face as well, which corroborated the information that was given by Ms. Williams. The defendant, there was a warrant taken out on the defendant. Obviously, he was arrested and charged accordingly. I have spoken with the victim, Ms. Williams, in this case. She is still having some residual recovery from her injuries from being pushed out of this moving vehicle. She doesn't want to have any contact or anything to do with Mr. McDowell. She says she has moved on with her life. She does think that he needs time incarcerated to reflect on his actions. But other than that, Your Honor, that is all from the state.
Anything else? Mr. Brown?
What's your factual?
If this case was to proceed to trial, the state would expect to prove beyond a reasonable doubt that on October 24th, 2020, victim Jakari Williams was shot twice by the defendants, Demetrius McDowell Sr. and Demetrius McDowell Jr. Mr. Williams was inside of the residence and noticed a cream-colored Toyota Camry and a silver Nissan Murano or Rogue that had been circling the residence. He recognized both of the drivers as Demetrius McDowell Sr., aka Big Meat, and Demetrius McDowell Jr., aka Little Meat. Mr. McDowell Sr. And Jr. live at on the adjacent street on Florida Avenue and Windward Drive. The defendant stopped in front of the incident location and asked for some substance, and said they were looking for a gentleman who was selling a car that lives there. Witnesses witnessed that that both defendants were asking questions about the vehicle. Witness Shelton stated to the police that after the questions, both defendants began shooting at the front of the location, which was 243 Florida Avenue Southwest in Fulton County. Witnesses saw both defendants begin shooting at the location, striking the victim, Jakari Williams, twice in the forearm. Police were called, and the victim was transported to Atlanta Medical Center with heavy blood loss.
Anything else?
No, Your Honor. As I said, this is negotiated as to all three cases. We would ask that you accept it.
Anything else from the state?
Your Honor.
Nothing further.
All right, so for position 2, 23 SC 189047, I'll accept the executive plea. No further contact with Diana Williams, no drugs, no alcohol, no weapons, no replicas of weapons. You got to stay away from MARTA, bus, trains, planes, automobile, anything at MARTA, okay?
Yes, ma'am.
Did he live somewhere outside of Fulton County when he gets out?
I don't know, Judge. I'm pretty sure he's going to be in Fulton County. That's where his mom lives.
All right. Let's see, on number 4, 23 SC 187394. I'll accept that. No further contact with Corey Williams, no drugs, no alcohol, no weapons, no replicas of weapons. I'll accept that as a negotiated plea. And number 7, 24 SC 002947. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Okay, as you said before, no contact with anybody that's a member of sex, money, murder, CDP, or any other gang or affiliates. No further contact with Keontae Jackson. Quavius Everson, Roderick Butler. In social media. I would say no further contact with victim's family, so of course, that's your family.
That's his family. So, yeah.
Will testify at trial truthfully, and you're saying right now that the statement you gave the detective in this case was true and correct.
Yes, ma'am.
I'll accept this plea also, I'll accept all of this free and voluntarily. Given the press and been properly advised by Mr. Melnick, Ms. McDowell, I hope that Calvin's memory brings you, comfort. And his memory should be a blessing, and I'm sorry for your loss in both instances, okay? All right, best of luck to you, best of luck to you.
Your Honor, if I may, there was a Fourth Amendment waiver as well on 2147.
All right, and that Fourth Amendment.
Thank you.
The time that he has served in custody, Judge. Yes. All right. Thank you.
All right, thanks.
I've got him here, but the state needs to sign him.
Mr. Brown can sign one of them and I'll sign the other.
Okay.